Hello, welcome to Habeas Humor. This is Sharon, and this is an unplanned Chauvin chunk.
Giving our views on the legal news.
Chauvin chunks. There has been a bit of activity in the case, and I just wanted to give you a quick update. This is not going to be very in-depth. It's just basically a news briefing. Here's what has happened since the June 25th sentencing hearing. On July 7th, the Minnesota Attorney General filed a letter with the court regarding the sentencing decision. They're not asking for any change to the sentence, but they're looking for a correction about the aggravating sentencing factor with regard to children being present at the scene of the crime. You'll remember that we discussed that in the previous episode. Minnesota Attorney General Keith Ellison writes to Judge Cahill saying, "On behalf of the state of Minnesota, I write to respectfully request that the court modify pages 16 to 17 of its sentencing memorandum opinion relating to the presence of children aggravating factor. The state expressly does not request that the court modify any part of the defendant's 22.5-year sentence for the murder of George Floyd. Rather, the state asks that the court modify two aspects of its analysis of the presence of children factor to correct the public record, more accurately reflect the experiences of the four children who witnessed Mr. Floyd's murder and subsequently testified at trial, and prevent potentially causing further harm by discounting the trauma suffered by these young girls." Now, the reason that this is relevant is because in the court's lengthy sentencing memorandum, where all of the factors for this sentence are discussed, the court actually says that the presence of children at the scene during the commission of the offense is not being used as a substantial and compelling reason for an upward durational departure under the circumstances of this case. Judge Cahill says, in contrast to the other aggravating factors which we had discussed, which was the unusual cruelty and the abuse of authority or abuse of powerful position, the judge says, in contrast to those factors, while the court finds that children were present during the commission of the offense, factually, the court concludes that the presence of the factor does not present a substantial and compelling reason for an upward durational departure. I'm reading from the judge's opinion here, quote, "The state presented testimony at trial from three young women who were 17 at the time of the incident, ... Although all four were present on the sidewalk for portions of the 9.5-minute interlude in which Mr. Chauvin, Lane, and Kung restrained Mr. Floyd prone on Chicago Avenue while Mr. Tao maintained a watchful eye on the onlooking bystanders, none was a victim in the sense of being physically injured or threatened with injury so long as they remained on the sidewalk and did not physically engage or interfere. None of them had been present when the officers were struggling with Mr. Floyd to get him into the squad car and only came upon the scene after he had already been subdued and was being restrained prone on the street." And I'm going to paraphrase from here on. Chauvin pointed out that they could have left, but I believe that wasn't one of them taking the video, like they shouldn't. I mean, this is not so sure I agree with Judge Cahill here. The judge says, quote, "Although the state contends that all four of these young women were traumatized by witnessing this incident, the evidence at trial did not present any objective indicia of trauma. To the contrary, Ms. Frazier, who recorded several minutes of Mr. Floyd's restraint on her cell phone and subsequently posted that video to a social network site, Ms. Funari, who also recorded several minutes of the restraint using Ms. Gilbert's cell phone, and JR would be probably the younger one. Oh yeah, the 9-year-old. I guess that's the law in Minnesota. I guess if you're 17, they'll use your name. But if you're 9, they won't." The judge's opinion here says that the kids, including JR, the 9-year-old, were observed smiling and occasionally even laughing over the course of the several minutes. Sorry about the motorcycle in the background. Quote, "In other words, while the presence of children is an aggravated sentencing factor and a permissible ground for departure for purposes of the first stage analysis, under the second stage of the analysis, the court does not find that specific facts in this case are so substantial and compelling to warrant an upward durational departure on this ground," end quote. So what the judge is saying is that while he did exceed the typical recommended sentence for second-degree murder, which I'm going off of my memory here, we talked about it in the last episode. I want to say it was 180 months which again, only 2/3 of the sentence is in prison, and then the last is essentially parole. The judge did give more than that, 22 and a half years, which means 15 on the inside, but this was not a factor in that. The minors being present was not a factor. The Attorney General therefore wanted an amendment to this. The Attorney General writes that the state first requests that the court remove the suggestion that because the children were not forcibly held at the scene or otherwise prevented from leaving, that an aggravating factor should not apply. Attorney General argues that this is contrary to law and to common sense. The Minnesota Supreme Court has clearly stated that an aggravating factor applies when children witness criminal activity. Children lack the adult capacity for decision making, including the ability to maturely walk away, quote unquote. Moreover, the law does not place the burden on a child to choose between staying, whether to stand witness or in an attempt to aid a victim, or leaving the scene of a crime. For good reason. The responsibility of shielding a child from witnessing a crime should not fall on the child. In other words, under Minnesota law, a child is akin to a victim when she perceives a horrific event, such as a murder, without anything more. It's a good point. The letter goes on to say the state is deeply worried about the message sent by suggesting that instead of attempting to intervene in order to stop a crime, which children did in this case, children should simply walk away and ignore their moral compasses. The state therefore asks that the court remove the phrases, quote, were free to leave the scene whenever they wished, end quote, and, quote, were never coerced or forced by him or any of the other officers to remain a captive presence at the scene, end quote, from page 16 of the opinion. Second, the state vehemently disagrees with the court's factual assertion that the demeanor of the children exhibited in the video of Mr. Floyd's death indicates that children were not traumatized. The children's emotional testimony at trial, including that one of them stays awake at night and another cannot return to Cup Foods, which was the store where the crime happened, belies that conclusion. Third, the best social science research supports modifying the opinion's reliance on the children's demeanor. Although the court's opinion ignored the fact that the children courageously confronted Mr. Chauvin and his co-defendants by pleading repeatedly for Mr. Chauvin to remove his knee from Mr. Floyd's neck so that he could breathe, and by begging Mr. Chauvin and his co-defendants to check Mr. Floyd's pulse, the opinion relied on its observation that the children smiled or giggled at various points during the incident, but that observation is completely immaterial. Children process traumatic experiences in ways that may seem unusual to the untrained eye, and he cites to a psychological study. Moreover, as social science research demonstrates, for humans of all ages, giggling or smiling can actually be normal responses to stressful experiences, cites to another study. Additionally, and particularly relevant here, research demonstrates that adults view black girls as less innocent and more adult-like than their white peers. And there's a cite to Rebecca Epstein and Jamila Blake and Talia Gonzalez. Girlhood Interrupted: The Erasure of Black Girls' Childhood in the Center on Poverty and Equality. I'll put a link to this in the notes. Looks like a journal article. The letter goes on to say, this phenomenon of adultification is unfortunately common in American society, including in the criminal justice system, and has led even careful observers to discount a young black girl's trauma. And then he cites another article by the same authors called Listening to Black Women and Girls, Lived Experiences and Adultification Bias, also from the Center on Poverty and Equality. Oh, and also Ann Batesel et al., Adultification of Black Children in Pediatric Anesthesia. Interesting. So I'll link those. But obviously that's relevant because the overarching problem of this whole case is the disparate treatment of black citizens versus white citizens. And it even extended, allegedly, to the evaluation of the witness testimony. The Attorney General also says in the letter, the state makes these requests with the utmost respect for the court, including its tremendous efforts to reduce implicit bias in this trial. And again, the state does not request here that the court modify the defendant's 22.5-year sentence in any way. This court found that 2 other aggravating factors supported an upward durational departure, and the court did not rely on the presence of children to enhance the defendant's sentence. As a result, modifying the portion of the opinion relating to the presence of children factor will not impact the defendant's 22.5-year sentence, but discounting the trauma of the children who testified at trial in an authoritative judicial opinion, no less, will only exacerbate the trauma they have suffered. The court should correct the public record to avoid that result. So that's very impactful because, for one thing, the Attorney General is acknowledging that this judge was doing his very best to be unbiased. And it also shows that even when we do our very best to be unbiased, we still have unconscious biases. And a lot of people just don't acknowledge that. And we don't want these witnesses who have already gone through a bunch of trauma to, on top of that, have the trauma of feeling discriminated against and silenced slash not listened to slash adultified by the justice system. I'm sure, just like the fact that there are 3 articles linked here, we could have this discussion for a long time, and I am no expert in this, so I'm not the person to have the discussion, really. So there are a couple of other sections to the letter, and of course it's linked for you to take a look at it yourself. The Attorney General says that the law does not require children to be unable to walk away in order to consider them traumatized by witnessing a crime and consider that relevant to sentencing. And the court should remove the language suggesting that the children were not traumatized, and they cite to the evidence for that. They also attached as support a sworn statement by Sarah Yvonne Vinson, a triple board certified child and adolescent adult and forensic psychiatrist, who says that she watched the testimony of all of the 4 minors who testified, and with a reasonable degree of medical certainty, she concludes that understanding the potential psychological harm to minors as a result of exposure to a violent crime requires a multifaceted approach, particularly in a situation such as this one. As an adult, Derek Chauvin had an inherent degree of authority over the minor witnesses. In addition, all minor witnesses identified defendant Chauvin as a police officer, which is notable because of the state-sanctioned authority conveyed by that title. 2 of the minors are black, the same race as the victim, which is notable because this shared characteristics may engender identification with the victim. She doesn't have any evidence regarding the race of the other 2 witnesses. Given the nature of the underlying crime in the case, a murder by an authority figure, it would be expected and should be presumed that the children who bore witness to this experienced trauma. Although there was no specific inquiry into the psychological impact these children experienced, the limited information we have, primarily the trial testimony of the children about their thoughts and feelings, indicates that the witnesses experienced trauma. One also cannot draw any inference about the trauma the minor witnesses experienced from the fact that they may have briefly laughed during the incident. Indeed, laughter can be a means of coping with distressing emotional states. That's true for me. I'm interjecting, obviously. I am a big example of the joking to cope with trauma. Like, my partner, it often gets uncomfortable with all the Holocaust jokes I make because I just can't process that trauma. I didn't even go through the Holocaust, obviously, but I've been taught about it my entire life, coming from a Jewish family that was directly impacted by it. So, that's one thing that Jews are known for, is making jokes about things. We're big in comedy. During the 20th century, there's been a lot of comedies that make fun of Nazis and stuff, and that's the reason. Anyway, going back to the psychiatrist's statement, she says, considering the laughter in the larger context, including that the laughter was not sustained, that the children were witnessing a murder at the time, that their behavior and testimony on the stand reflected negative emotional internal states associated with the incident, and that they were developmentally immature given their young ages, the most reasonable explanation is that the laughter was a stress response. She goes on to say, any evaluation of the children's psychological condition must also take into account both the history of violence toward Black Americans and the well-known cognitive biases that can lead someone to discount the trauma of young Black children. The denial of trauma, especially by an authority figure, can be traumatic in and of itself. Therefore, discounting the children's own accounts of their experiences has the potential to exacerbate the harm to the minors' psyches in this case. She goes on to make more points about power differentials, minors versus adults, and state actors versus citizens. And she goes on, there's a section about structural racism and racial trauma. She talks about adultification and the risk of adultification bias. And of course, this is linked for you to take a look at. It's like 14 pages long, so I can't cover everything. But I regret to have to tell you that about a week after this was filed, it was filed on July 7th, and then on July 13th, the judge denied this motion. And he wrote a memorandum explaining the decision, and he throws some shade. Wow. He says, although the state's July 7th letter does not cite any statutes or rules, it contends invest this court. That's got to be a typo. Maybe he means it contends to invest this court with jurisdiction over this case now that sentence has been imposed and the defendant has been committed to the custody of the Commissioner of Corrections. So the judge starts off saying, like, he doesn't even believe he has the right to do anything further in the case, which I don't think that's correct. To my knowledge, a judge always has the ability to modify an order or to like correct an opinion or something, especially if it's not even changing the result or outcome. It's not like the judge cites any rule or law stating that they don't have jurisdiction. The judge goes on to say, the court believes the tone and substance of the letter requesting modification of the court's sentencing memorandum opinion and the manner in which the letter mischaracterizes the memorandum opinion and the record in this case necessitate a response. First and most fundamentally, the state's July 7th letter misperceives what should be the court's focus in this case. Defendant's conduct toward George Floyd on May 25th, 2020, the basis upon which the jury found the defendant guilty of unintentional second-degree and third-degree murder and second-degree manslaughter. So he's saying that it's about the conduct, not the trauma on the witnesses. That's what I think he's saying, and that doesn't make any sense. Like, of course, the court always takes into account the effects on the victim when they pass a sentence. He says, second, the court neither found nor wrote in the sentencing memorandum opinion that the 4 eyewitnesses were not traumatized. What the court wrote is that the evidence at trial did not present any objective indicia of trauma. The court noted video evidence from the trial suggestive of a lack of contemporaneous emotional trauma at the time. It is certainly possible that the witnesses experienced some level of emotional trauma, but the state failed to prove it. I don't know, Judge Cahill. I mean, I'm not an expert in Minnesota procedure. Now, this would be a little bit different from just a sentencing hearing where, victims read their victim impact statements and stuff. They also had, if you'll remember from the last episode, an actual portion of the trial to establish the aggravating factors. So he's saying that, pursuant to the rules of evidence in that trial, the aggravating factors were not proven. And it would be great if anyone out there with more knowledge on this legally would correct me if I'm wrong. But from what we went over before, the laws and the rules of sentencing, all you had to prove was that children were present. It didn't say you had to prove like complex psychological evidence about the trauma they went through. You had testimony at the sentencing hearing. Isn't that what the sentencing hearing is for? All those victim impact statements? Like, are those not supposed to have any effect? It's certainly... because the judge had the whole memorandum opinion ready and the sentence ready right when everyone was done, it certainly looked like that had no effect, which was a little, you'll remember that I commented, that was a little weird. Or actually, in the script that I'm working on for the next Chauvin chunk, I comment that that's a little weird. But because I made the last episode actually before the sentencing hearing, I didn't comment on that. But isn't traditionally, and please any criminal practitioner who's maybe listening or watching, please let me know. Like, isn't that the whole point of the sentencing hearing itself? Victims and witnesses read their statements or give their testimony and talk about their trauma and everything. Like, isn't that supposed to have an effect? Isn't that supposed to be legitimate, if not evidence, then information that will weigh on the court's decision in sentencing? I mean, the court seems to be really turning its back on the fact that it really did. We read the sentencing memorandum in part where it kind of talks about, it's a little bit flippant about the kids. Like, oh, they were there, they could have left, and they were laughing. Like, I don't know if there's a reason underlying all of this where Judge Cahill really feels he has to be just dismiss the whole thing, but it's not a good look. Anyhow, he goes on for several more pages, talking about he's not trying to send a message of any kind. He emphatically rejects the implication that he was in any way, like, adultifying the black girls. He's really relying on case law and stuff about aggravating factors. And for all I know, he's right legally. It would take me a really long time to really read up on all that stuff and become an expert in Minnesota sentencing precedent. So I just don't know. But that's how that ended up. And to me, it seems unfortunate. Again, legally, this is completely out of my wheelhouse, and I just don't know what he could have or should have done. So the other thing that has happened is that the press has asked to unseal the juror identities. And this was filed on August 4th. This motion was filed by the American Public Media Group, which owns Minnesota Public Radio, the Associated Press, Cable News Network, Inc., that's CNN, CBS Broadcasting, Inc., Court TV Media, LLC, Dow Jones and Company, which publishes the Wall Street Journal, Minnesota Coalition on Government Information, NBC Universal Media, the New York Times, and then many others, basically anyone you would expect. They submit a motion to unseal juror identities and other juror materials. Oh, and this lawyer, who's this lawyer here? Because they're bringing the drama. The firm Ballard Spahr, LLP, attorneys for Media Coalition. Leda Walker from Minneapolis, and Emmy Parsons, Pro Hoc Vice, which, if you'll remember from My Cousin Vinny, is where an out-of-state attorney can get a one-time waiver from the court to practice law in the state for the purposes of the case. So here's the introduction. This is not a motion that the Media Coalition brings lightly, or for that matter, quickly. It is weighted through trial, through verdict, through sentencing, and until now, more than 3 months after the jurors completed their service in the trial of Derek Chauvin, out of respect for the integrity of the proceedings, for the court's articulated concerns about juror impartiality and safety, and for the jurors themselves who served their community under very difficult circumstances and handled harrowing evidence and testimony. The passage of time and subsequent events, however, have resolved many of those concerns and further demonstrated that the public interest in this case and the national reckoning to which it gave rise make transparency regarding the identities, backgrounds, and predilections of the people who handed down the verdict more important, not less. Wow, so they want to know not just the identities of the jurors, but their backgrounds and predilections? Predilections, in case you don't know, means like things they like. Like, do they like chocolate ice cream or vanilla? It's very important. The public needs to know. Continuing on, during the delay in bringing this motion, the Twin Cities community, in fact the country, appears to have found some peace in the M following Mr. That's another typo. You guys, editing, proofreading. I think they mean months. The jurors' verdict led not to a repeat of the destructive unrest that arose in response to Mr. Floyd's tragic death, but to celebrations and demonstrations that one news outlet called jubilant and a moment of catharsis, while describing Minneapolis as a scene of collective relief and satisfaction. I mean, that's kind of true, but they should pay more attention to right-wing media, because those assholes are still talking about this. I don't ever advocate listening to or watching Nick Fuentes, but remember at CPAC, or outside of CPAC, when he promised to give like the most racist speech ever, he said some really bad shit about George Floyd. This is sticking in the craw of the right wing for sure. So further down, the memorandum says, consistent with our constitutional principles, I think they mean freedom of the press, and well-settled legal precedent, it is now time to make public information about the jurors who served in this case. As this court has recognized, our legal system is an open one, and it cannot keep juror identities a secret forever. As explained in greater detail below, identification of jurors is a central feature of our criminal justice system, not a flaw or an afterthought, and the common refrain among laypersons that they did their duty, now leave them alone, ignores the full scope of a juror's responsibility. And they just go on about how it's essential to justice and, the integrity of the court system that jurors' identities be public. They cite law, including the First Amendment. And then the conclusion says the Media Coalition does not have to justify its interest in jurors' identities, profiles, or questionnaires, or explain in detail how it may use information it has not been able to see. For the reasons discussed above, it is presumptively entitled to that information under court rules, the common law, and the First Amendment. But it bears noting that simply knowing who the jurors are, even if they never speak to the press, helps the public learn whether they were suitable decision makers. They actually cite a case regarding Blagojevich, if you remember, the Illinois governor turned criminal. And they cite case law that says information about jurors obtained from the jurors themselves or otherwise serves to educate the public regarding the judicial system and can be important to public debate about its strengths, flaws, and means to improve it. Whether members of the jury choose to grant or decline press interviews regarding their service, the identities of the jury members may still be important to inform the public about the jury selection process, the conduct of the trial, or the criminal justice system in general. For this and all the reasons discussed above, the court should immediately disclose the jurors' identities to the press and the public, should unseal the related juror materials, including the prospective juror list, juror profiles, juror questionnaires, and the unredacted verdict forms. And in support of their motion, they filed an affidavit by Susan Suki Dardarian, Queen of the Dragons, kidding, Senior Managing Editor and Vice President of the Star Tribune Media Company, LLC. She says the Media Coalition covering the above criminal case have treated all trial participants, including jurors, with respect. She's been a journalist for nearly 40 years. Most of her time as a reporter and editor has involved coverage of courts and the justice system. She's only aware of one other instance in which a court kept sealed all names and information about impaneled jurors for such a lengthy period of time, which was the criminal prosecution of former Minneapolis police officer Mohammed Noor. You'll have to Google that one on your own. This is supposed to be streamlined. This is a quick news briefing. In general, the opposite is true. Almost always, my newspapers have sought and received near contemporaneous access to the names of jurors in high-profile trials. For example, Star Tribune sought and received the names of jurors in the following cases, most of which were high-profile. She gives 6 examples, and she puts the news articles covering those. The first one was the 2019 trial of Stephen Friends on 1 count of felony perjury. Apparently this was a Minneapolis landlord who was convicted of felony perjury, covered in the Star Tribune. The next one was the 2017 trial of Geronimo Yanez, the police officer who killed Philando Castile. She attaches an article from the Star Tribune with the headline, 2 holdouts on Yanez jury changed minds on Friday, juror says. She cites the 2014 libel trial involving former Governor Jesse Ventura against the estate of Navy SEAL and American sniper author Chris Kyle. Fourth is the trial of James Fry in 2013. Fifth is the 2012 trial of Amy Sensor on 2 counts of criminal vehicular homicide. And lastly, the 2009 trial of Dominic Jones for rape and unwanted sexual contact. And she concludes by saying, I do not believe this case merits different treatment. If anything, the degree of public interest and concern it attracted warrants more transparency. And on August 16th, 2021, the state filed a memorandum opposing the motion to unseal the juror identities. This is the last thing that has been filed in the case. This was yesterday, so the judge has not made a decision on this. I mean, I don't know if the judge will make a decision. He says he has no more jurisdiction now that the defendant is in criminal custody. See how ridiculous that is? So the state, of course, has to match the drama. So this introduction says, quote, in the midst of intense scrutiny and in the face of public health crisis, this court oversaw the most open trial in American history. Millions watched these public proceedings gavel to gavel, vindicating the concerns of the victims and the community in knowing that defendant Derek Chauvin was tried by jurors fairly and openly selected. The memorandum goes on to say, against this highly public backdrop and in light of well-documented findings, the court crafted an extremely narrow order to protect jurors' identities and ameliorate any need for more intrusive alternatives such as full sequestration. Sequestration means where they sequester the jury, like make them stay in a hotel and not have contact with anyone, that kind of thing. The court's efforts ensured that defendant Chauvin received a fair trial despite the intense passions surrounding this unique case. After the verdict, the court extended the jurors' anonymity for at least 180 days to protect jurors from harassment. The state opposes the Media Coalition's motion to release the jurors' identities nearly 3 months before the court's 180-day deadline for revisiting the issue. The court should not revisit its order mere months before the criminal trial for Mr. Chauvin's 3 co-defendants in advance of potential federal proceedings, when the likelihood of harassment will increase in the coming months and the marginal value of disclosure is low. That's true, they haven't had the co-defendants' trial yet or the federal trial. Once this court releases jury information, it cannot turn back, even if that disclosure proves premature. The genie out of the bottle argument. The toothpaste back in the tube argument. Moreover, releasing juror materials now would hamper efforts to assure prospective jurors in March 2022 trial involving Mr. Chauvin's 3 co-defendants that their identities will be protected. Procedural rules, the common law, and the First Amendment will all permit the court to protect jurors from harassment in these extraordinary circumstances. Yada, yada, yada. So again, I'm going to link the whole memorandum if you want to read it. It's like 23 pages long. My prediction, the court will deny the motion to release the jurors' identities. It hasn't even been 180 days. I don't know why the press is chomping at the bit. Well, I know why, probably. But, because they want to know. They want their stories. I guess they don't have enough to cover right now. But given the fact that it hasn't even been 180 days and the other trials are still pending, I don't think the court is going to release the jurors' identities or any of the juror documents. So that's it for this Chauvin chunk. Just wanted to give you the update. We still need to do the dive into the charges and the jury instructions, so I'm working on that. Also, in case you didn't know, I post on YouTube a few times a week a live run through the New York Times crossword puzzle, so you get to watch me flounder with that. So I hope you have a wonderful rest of your week, and stay legal, my friends.